Ahora sí. Today we are here to be part of this masterclass where we will learn about the intellectual property regulation in the major Asian economies with Professor Kung-Shun Liu. We think that this masterclass is the best way to learn about intellectual property. And it's the best way to learn about the regulation in the Asian continent. Professor, sorry for that. Professor Kung-Shun Liu is the right specialist for that. He is currently working in the Yong Pung Shaw School of Law, Singapore Management University, Renmin University of China, National Shenxi University of Taiwan, and the National Law University of Delhi. Professor, is all yours.
So, many thanks for your kind introduction, and a big warm welcome to you all, either people who are physically here and people who are online with us. It's a great honor and pleasure to be the first Asian Ivy scholar to speak to you people from University of Austral. Okay, and my topic, since I come from Asia, so my topic will be on the importance of study Asian IP law, and I will try to speak for 45 minutes, and I will stop for some 15 minutes for Q&A. Right. So actually, I was invited to Singapore Management University in 2013 when I was 53 years old. Actually, I was too old to travel. So initially, I said no to the invitation, but they insisted in having me to set up an IP center there with a focus on Asian IP. So after some thoughts, I went there and set up an Asian IP center. I then enjoyed my work very much because I saw a mission, the work that I do. Although we are not the politician, but as the simple law professors, we want to make contribution to peace, at least in our part of the world. So I see IP as a very important instrument for facilitating understanding and peace in Asia. So that's why I decided to go to Singapore in the age of 53, and I've been there since 2014. Okay, so that's why I took the so-called journey to Asian IP law. Okay, I've been there since 2014. There are three main focus of the work that I'm doing. Okay? One is to facilitate the understanding and exchange between the two Asian giants of China and India. We all know these two countries don't get along very well, although they know each other over 1,000 years. So I started to play the role of a bridge, since Singapore sits nicely between China and India. And also we have an Indian population as well as Chinese population. So I think this is an ideal place for us to play this bridging role. And therefore I started to make a comparative study between India and China, and very quickly, more than I can expect, that I published two books on India and China. So the second book actually was then published in 2019. Okay, it's an open access book. So if you are interested, you can just download the whole book. I don't have the updated downloading number, but the latest number I had is over 25,000 downloads. Okay, so that means people are very interested in the comparative study between India and China to see what role IP has played in the development of 6 chosen industrial sectors, which include film industry, pharmaceutical industry, and automobile industry. And we explore whether two sides then can help each other and learn from each other. Indeed, as it turned out, there are many places where both sides can synergize or both sides can cooperate. And we see overwhelming response from audience from the two countries. So this is something that I continue, I contemplate in continuing to do to bridge India and China. That I said will surely help peace in Asia. Okay. Yeah. Then the other major area that I run. Is I try to present some of the most characteristics features of Asian IP laws. So actually, before myself, there's no such thing as Asian IP law. People just don't know what Asian IP law is, or whether there is such thing as Asian IP law. So then I just did my homework, some groundwork. So I then started to. I have also published one trilogy to see some of the most important legal topics in some of the major Asian jurisdictions, covering patent, copyright, and trademark. So this has been published. And last year, then I started my second trilogy to talk about trade secret protection in Asia. And we are very much under the influence of the US. So we try to see trade secret as some kind of absolute property. And we try to protect them with very severe criminal punishment. But I wonder whether this is the right way to go. As you can see, I then try to show people that there are some commonality between major Asian jurisdictions, and there are indeed some insights from major Asian economies. Then the third pillar of my journey to Asian trip is then to look at the Asian perspectives on IP. Okay, so as we all know, IP are set by the Western countries according to their national developmental needs. That doesn't necessarily suit Asian situations. Okay, so then it's important that people reflect on this and try to emphasize our special situations and voice our concerns. So then I try to bring forward many of the Asian perspectives by involving many Asian IP scholars. So if you then take, for example, this book on compulsory patent licensing. This is a very interesting book with Carlos Correa. He was one of the contributing authors on this book. So we think the compulsory licensing is an important issue that has been underestimated. So with the risings of the interconnected world and also in the internet, I think compulsory licensing can be a very important instrument to strike the proper balance between IP right holders and public interest. Okay, so we published a book in 2015. Then similarly, then we try to advocate the idea that, well, it's important actually to allow copyright holders to get money that they deserve, not that you just talked about their rights in absolute terms. So it's very important that we provide the actual remuneration to copyright holders. Then we see regulatory challenges of new business model. Right, and then we talked about the intersection between trade law and IP law. But traditionally, these two areas, they don't intersect with one another. Trade law professors, they don't talk to IP professors. But it's not the case anymore with the introductions of TRIPS, because then IP has now become a standard component of international trade negotiations. So we couldn't possibly ignore the influence of trade law on IP. And most importantly, then I think this is also an interesting book on the SEP, Standard Essential Patents, Standard Setting Organization, and Frame Licensing. So what are the Asian perspective on this important topics? So prior to my books, there's nothing of any of this sort. But that doesn't mean that there isn't any Asian standard to begin with. So I then sorry. Sí, claro. Right. So it's important that right. So in terms of frame license of SEPs, fair, reasonable, non-discriminatory licensing of standard essential patents. I think there are indeed some Asian standards, some Asian legal standards that need to be taken into account, okay? Because then Asian economy, we have this basic fundamental characteristic of being standard takers. We take standards, we don't make standards. So we follow standards and we implement standard essential patents. We don't invent SEP. And therefore that marked the fundamental difference between Asian economy and the Western economy, where they actually set the standards and they invent the SEP. So we have a different economic constellation. Therefore, we must have different legal standards when it comes to the actual determinations of frame terms. How do you identify frame terms? Okay, since we are at the receiving side, we receive the standard, we receive the SEP, and we are also on the paying side. We are paying the royalty. So then we think very differently from SEP patentees and the standard setting organizations. So my study showed that there are certain standards on frame licensing of SEPs that have then converged in major Asian jurisdictions such as Japan, Korea, China, Taiwan, and India. I can summarize this commonality into so-called 3 no's and 1 yes. So we don't like the first note is that we don't like the bundling of non-SEP with SEP. Okay, we like to pay for things that we actually have use for. So we want only to pay for SEP. Once you bundle non-SEP with SEP, then it will then require us to pay for something we don't have actual use for. So it will not be accepted in these Asian jurisdictions. The second clear no is then no to continue payment of royalty after the expirations of SEPs, period. Okay, we just honor the patent, but the moment it expires, it must flow back to public domain for everyone to use for free. This is a public policy issue we must uphold. So if the patentee asks the licensee to continue to pay, then it will not be accepted. But this is pretty much the first two are common practice in SEP licensing. Okay, SEP patentee will say, "Wow, this is a portfolio management. Okay, just take it as a package. And don't worry about overpaying us. No. Because this is a living patent portfolio. Some patent will expire, but some new patent will be flowing in. So therefore, you are not overpaying us. So don't worry about this. But we think very differently because, as I said, we are on the receiving end of sales. We are paying of royalty. We don't like to overpay. And the third clear no is no to royalty-free cross-licensing. Of course, patentee would like to have the cross-licensing. This is understandable, but they have to be on an equal term, not that they want, they ask or demand the licensee to give it back, grant it back for free. And one positive yes is that, well, when SEP patentee negotiate licensing agreements with its willing or future possible licensee, they must be transparent. They must provide a patent list, which are actually at the fingertip, right? They must have this patent portfolio management information at their fingertip. They should actually provide to make the transactions more transparent. So this legal standards reflect economic realities in Asian economies. And they have to respect this economic reality. Not that we want to be ideologically different from the West, but simply we have different economic situation, reality that we have to deal with. So then, after working there in Singapore for 8 years, now I will publish a book. Actually, the book will be out on the 11th of August. Okay, it will be published by Routledge. So pretty much I summarized the work that I've been doing in the last 80 years in the book that I call IP Laws and Regimes in Major Asian Economies. And with a subtitle of Combing Through Thousand Threads of IP to Peace in Asia. So it's very much at the bottom of my heart that I want to use IP as a tool for peace in Asia. And I will explain to you why I have great concern that peace is not something that comes very cheaply and easily in Asia. Right, so then perhaps you will ask, well, Prof, how can you do a book on the Asian IP law? Asia is so huge. We have 60% of the global population, right? And the culture, the language, so diverse and so different. How can I do a book like this? If you say that, it's perfectly legitimate, but I focus on the so-called major economies, which are actually leading the development of IP in Asia. And there are some tier 2 or tier 3 Asian countries, at the end of the day, they will catch up. So my main focus is that some of the 10 major Asian economies. And also, I try to choose the best topics that somehow give the best snapshots of IP landscapes in these Asian economies, so that better reflect the actual situation on the ground in Asia. Whether this is a successful enterprise or work, you can do your own judgment. But I think my book is really about the struggle of Asian IP laws. So we went through 3 stages. Okay, one is then we transplant. We just take everything that was then imposed on us, then we try to internalize this. So to make it part of our actual mindset and part of our daily life. Okay, it takes time. You simply couldn't do it by fast tracking everything. You have to then wait, be patient to build this social trust and social contract. And then we now are on the 3rd stage of development. I think more or less we are now in the position to give back to the international IP community after practicing our own versions of IP law for so many years. So I think there are indeed some Asian features and insights that we can personalize and offer to the international IP community. So Sebastian is doing similar work. I wish him all the best, but I think this is a standard process. You have to go through this. You just imitate. But you have to internalize this. You have to make your own belief. But then you will be on the equal footing with the international members and try to give your feedback to the betterment of international IP regime. Right? So yes, there are 10 chapters in my book. So most important is that I give an overview of Asian modern history and also of the history of Asian IP laws. I think the past is very important. The present and the future is actually a continuum of the past, so we can never get rid of the past. And only by understanding the past, we'll have a better understanding for the present and a better planning for the futures. And then I talked specifically about the pre-established damages for copyright infringement and trademark counterfeit. But that perhaps is too technical. But then I also talked about trade secrets. So my basic foundation is really we have to base our legal IP regime or the design of IP regime on our commercial realities. So in terms of trade secret protection, for example, we are not the US, right? US is the most innovative country. They are the primary target of international economic espionage, right? But Asia, no, come on. Only Japan is the net exporter of technology. The rest of us, we're just importer of technology. We're good at scaling up mass production, cutting costs. We are very dependent on the importations of technology. So it will not be in the Asian interest to have very strong criminal protection for trade secrets. Okay, so my point being really that we should base our IP regime on our commercial realities. And then we couldn't talk about Asian IP law without taking a closer look at the development of China. Okay, what happened in China is really amazing in the last 40 years. Lucas has rightly pointed out. The political regime is not something that we can learn, but the way they structure, organize the economic development, especially the development of IP law, is really amazing. We have to give them due credit. So just within a short span of 40 years, they have transformed themselves from IP follower into IP game changers. So it is likely that they will have a greater impact on future development of IP internationally. So it's important to take a closer look at China and also, as I mentioned, the comparative study between India and China. India is very innovative in tailor-making their IP regime to suit their national developmental needs. They are genius. Chinese can learn a lot from them. I think Latin America can also learn a lot from India. And then I talked about a mid-sized and one small-sized Asian economy on its respective struggles and success. So, for example, Singapore, where I come from, is just a harbor or city country, city-state, but they have successfully utilized IP as a catalyst to boost the economic development. And now Darren Gan is now the current secretary of WIPO, is actually the commemorations of their achievement. So these are all very, at least to me, all very interesting stories to tell, or IP story, if you will, to tell to the rest of the world. Right. Right. Yes, as I mentioned, IP, we have the most population, 60%. We take up 30% of land area, and we are now world factory with a growth engine. We have the biggest market. We have the population bonus. Half of the people in India, for example, is under the age of 30, and China is pushing very hard for the One Belt One Road initiative. These actually all make Asia very relevant to the rest of the world. Right, and there are some, I think, some Asian tendency that will also affect the design of IP regime in Asia. For example, we have a tendency of collectivism. It's understandable with so many people there. So we couldn't possibly emphasize the individual freedom to the extreme. So we have to be honest about this, the tendency of collectivism. And people find no difficulty wearing masks, following orders, because this is for the benefit of the common good. So with this kind of collectivism, there's much room for public interest, considerations of maintaining public interest. And we also, there's also a lack of functional democracy. So parliaments in Asia are not parliaments, Bundestag in Germany. They are not the crystallizers of national consensus, no. Even in the area of IP law. So then IP law are mostly decided by technocrats working in the Ministry of Trade and Industry. Okay, and there are upsides and downsides of this kind of mechanism. I think clearly it has to do with the fact that generally in Asia we lack functional democracy. And one thing that drives the Asian IP regime is that pretty much all the major Asian economies, we are very development oriented. Every government tried to build its legitimacy by pushing the state to another higher level of development. People just don't stop. Japan, Korea, China, Hong Kong, Taiwan, and Singapore, every government is very keen on pushing even for more economic development. That's explained why IP regime in Asia is very top down. It's government driven. It is with very, very steady focus, and to some extent, we are quite successful. Right, and so when we talked about modern Asia, we couldn't be complete without mentioning the history of Asia being colonized by Europeans. Okay, but I won't trouble you with the historical details. So pretty much all the Europeans have their colony in Asia. So that then make the Asian landscape very complicated. Okay, so we pretty much reflect all the legal regimes in the whole world, right? So, Malaysia, for example, they become independent only in 1957, 12 years after the end of World War II. And Singapore broke away from Malaysia in 1965. So we are a young democracy, just 57 years old, right? Right, again, we see Asia being colonized by a European. So there are only a handful of independent states left. Okay, China, but pretty much China is being occupied by European powers. There are so many European settlements within China. And then Bhutan is a small country, Japan, Mongolia, Nepal, again, a very small country, and Thailand. So the whole of Asia has been pretty much colonized by the European power. Right. Then Japan played a leading role in the modernizations of Asia, but it has not always been the case. So in 1641, Japan shut its door to the rest of the world. I don't know if you remember, in 1642 in the UK, they enacted statutes of monopolies. Okay, this is where they encourage innovation by granting patents. But 1 year prior to that, Japan shut its door to the rest of the world. So that is a very telling dividing line. So for the next 2 centuries, Japan was pretty much free from Western influence. But that kind of closure has been forced open by the U.S. Marine, John Perry. So then they were forced to open up in 1854. So when Japan was forced to open itself up to the rest of the world, it's pretty much third world country. Okay, very, very poor, very broken, very backward, and they were forced to provide American national extraterritoriality. So America will not be tried by Japanese courts, and then many European power follow suit. So they become victimized by the European power. But you have to then give the Japanese due credit. They were very quick in understanding the importance of reforming Japan. So they very quickly, within 50 years, they transformed themselves from a third world country to the first world country, also with the help of IP. So Japan is the only Asian economy which embraced IP voluntarily. They perceive the importance of IP as an instrument for national development. So very early on, they introduced patent system, and then the whole set of IP laws. And this is why I said Japan is really leading Asian restoration, so to speak. And the rest of Asia, we are forced to take up IP regimes. Okay. But then Japan, although it very quickly, successfully transformed itself from a third world country to a superpower by the end of the 19th century, but it started to act like just the European, the colonized. They think, well, what the Europeans are now doing to the Asian, they can do the same thing. So they colonized Japan, Taiwan, they colonized Korea, and they defeated Russia in 1905, they annexed Korea in 1910. So they become very aggressive to the great disappointment of Asian people, because back then people were very thrilled by the Japanese success story. This is the first Asian country that has defeated Russia, European superpower. But then Japan decided just to act like one of those, the European power, and started to colonize the other part of Asia. And that led to bitter history. And that has a lasting effect until this very day. Okay, so we have a huge historical issue to deal with. Right, so this is the and one thing that made the history even worse is that while Japanese committed atrocity during World War II, so Japanese army, they were very different in terms of treating prisoners. Okay, in the World War I, they were very friendly to prisoner of war. So some German soldiers, they even after World War I, they were so well treated, they decided to stay on in Japan. But the Japanese, the Royal Army, behaved very differently during World War II. They committed atrocity in large part of Asia. So that also led to mistrust and hatred, which lasted until this very day. Right, so we don't really have a genuine Asian reconciliation to talk about. But Germany, they have made their genuine reconciliation with Europeans. So I was in Germany in the late 1980s when I was making my PhD degree there. I was a bit doubtful whether they have really been democratized, but now if you ask me, I think German people are by far the most trustworthy people, peace-loving people. The Nazi or neo-Nazi is a fake issue in Germany, but we don't have this kind of genuine reconciliation in Asia. So that's why I say Asia is perhaps one of the most dangerous places on Earth. Right. And then after World War II, communism has become a big issue in Asia. And that expansion is still affecting global affairs until this very day. And that can really be the trigger for, I don't know, possible third world war. Really, this is something very difficult to compromise. Okay, the theological differences between communism and democracy. So then we have all kinds of military conflicts among Asian neighbors. So territorial tension between Japan, Korea, Russia, Japan, China, India, Vietnam, Philippines, Taiwan, and India, and full war broke out between India and Pakistan. And also we have North Korea under the totalitarian regime of Kim Jong-un. So you can see Asia is very, although it is war factor, it is growth engine, right? It is driving the economic growth of the world. But at the same time, Asia is very dangerous because it is not integrated at all. We don't have anything, not even organizations of Latin America countries. No, we don't have anything in Asia. So that means that whenever we have dispute, we have to invite the US, we have to invite Russia, we have to invite external forces. And that is very destabilizing the situation in Asia. So then as I mentioned, we have all kinds of legal approach in Asia to reflect our colonial heritage. Right, so we don't really have an Asian institution, although we have some Asian Development Bank or APAC or CPTPP or RCEP or AIIB. No, these are not genuine Asian institutions. There's no harmonization, integrations. Right, and people don't talk about Asianization that much, okay? Not to my knowledge. There's one people talking about this in 1910. It's a Korean. He then advocates that the cooperation between China, Korea, and Japan, we should have a joint army and issue the same banknotes, currencies. But he's a loner. He's not very widely known. Right, the only Asian integration that we can talk about is the ASEAN, okay? But in ASEAN, again, it's not a formalistic legal approach. Everything is based on discreteness, informality, consensus. So it progressed at an extremely low pace, and nothing is institutionalized. So Burma, for example, can blackmail all other countries by saying, no, to all the initiatives. So we don't really have an Asian integration to talk about. And then we have TPP now. But the CPTPP is not, again, exclusive Asian. We also then have RCEP, okay? But again, RCEP is not an exclusive Asian creation. It has the members from such as Australia and New Zealand. But one thing worth noticing is that, well, RCEP can, to some extent, marks the dawn of a new age for IP. So although RCEP doesn't pursue higher level of IP protection, but set new standards. So he talked about the importance of pre-grant oppositions. And also he talked about experimental use exceptions to patent rights. This is a good answer to the expensive patent rights. So pretty much all other international IP treaty don't talk about this kind of mechanism that will help to curb expensive patent rights. So in that sense, well, RCEP marks the new dawn of a new age where major Asian economy can take a leading role in remolding international IP regime. Right. Right. Yes, as I mentioned, Japan is the only one Asian country that has voluntarily, willingly embraced IP as a mechanism to boost economic development. So very early on, they introduced a patent law in 1871. They are very practical. They abolished this the next year because people don't understand what patent law is about. So it took them another 14 years to reenact this, the first Patent Act in 1885. So that really makes Japan a strong economy, right? And the introductions of IP into other Asian economy is actually either a direct impositions by European powers. So India, early on, they introduced all kinds of IP laws, but not to protect Indian indigenous industry, but rather to protect British interests in India. That's the case in Singapore, Malaysia, and Hong Kong. Or then we introduced IP, we were only under the demand of European powers. This is the case in China very early on. And also, or we introduced IP law under trade pressure from the US after 1980. So US then pressurized us to introduce and reform our IP laws to provide sufficient protection for US IP interests. Right, so why Asian IP laws are interesting? Because I think for several reasons. One is that really we have the so-called IP success stories in Asia. So we then suffer from, at the beginning, we suffer from the introductions of IPs. IP was an actual cost for doing business. But then we live with IP, and then we internalize IP, and then we transform ourselves to become innovative rather than just imitate. So that, and then we started to benefit from IP when we reach certain level of economic development. That is the case for Japan in the 60s. That is the case for Korea, Taiwan in the 80s and 90s. The case for China, Hong Kong, Singapore after 2000, and this is the case even for India after 2010. So we are the best selling story, so to speak, for Michael. Follow IP, it will make you economically strong, and then you will benefit from IP. And we have actual examples. Pretty much these example, can be only found in Asia. Right, and also IP has become a common language for Asia. We are very divergent in all aspects of our understanding of the global affairs, but when it comes to IP, Asian economy have a strong consensus because then we are disciplined, constantly disciplined by the US. So we start by imitating what the US laws, and then we try to internalize this. And we try to use IP as a tool for national development. And so then you see there are all kinds of national IP strategy only in Asia. Okay, so starting from Japan in 2003. So now the Prime Minister is the chairman of this IP strategic headquarters. In China, they have a national IP strategy which extend to 2035. Okay, Korea, Taiwan, and Singapore, they have an update. That will then extend to 2030, and Cambodia, India, Thailand. Okay, so we are development-oriented, top-down, and then we very much believe in the utilities of IP. So many Asian jurisdictions, they enacted so-called IP Basic Act. Okay, this is the case for Japan and Korea. Now China is contemplating on enacting IP Basic Act as well. And then, as I mentioned earlier, the courts have played little role in the development of IP laws in major Asian economy. No, we are pretty much dependent on law, statutory laws that are being drafted by IP technocrats, government official working at the Ministry of Trade or Industry. So, as I said, they have it has this upsides and downsides. Okay, so by having IP technocrats chairing everything, it's very effective, right, and very professional. But at the same time, they are easily being captured by interest groups and lobbyists. Okay, so there's a serious issues of interest group, special interest groups in Asian economies. And sometimes the IP right trumped every other right, even basic human rights, consumer protection in some of the Asian major economies. So then, as part of this, the national IP strategy, we set up a specialized IP judges or specialized IP chambers or IP standalone IP courts. So I think it's fair to say that now Asia by far has the most experiences in adjudicating IP-related cases. Okay, so it's no exaggeration that Asia has the largest number of specialized IP judges and courts deal with the highest number of IP cases. So Japan started in 1950, set up a Tokyo IP High Court with a special chamber dealing with the IP issues. And then have the Tokyo and Osaka district courts have exclusive jurisdictions over technical legal issues. And then Korea, they set up a patent court following the German Patentgericht model, okay, in 1988. And they also introduced just recently, 2021, so-called international patent. So that at the patent court and 5 designated district courts in Korea, you can conduct litigation in English if you prefer. Okay, very courageous actually. So Thailand has its IP court, the Philippines, Indonesia, Taiwan, Singapore, and India. And China, again, they outdo everyone else. So they set up 3 IP courts in Beijing, Shanghai, and Guangzhou in 2014. The intermediary courts. dealing exclusively with the IP cases, but then the Supreme People's Court set up IP Court in 2019. So they just, the IP Court under the Supreme People's Court, they have the exclusive jurisdictions of all technical related IP cases for the whole of China. So these 60 judges, they are the most experienced IP judges for the whole world. But I'm not necessarily saying that this is the model for us to follow, but this is a good indicator of showing how China is serious about building IP expertise. So this is something we should pay attention to. Right, and there are some distinctively Asian IP developments. I have some. I'll talk about another 5 minutes, and then I will stop. Some interaction. Okay, so don't worry. So you have my slides. You're more than welcome to distribute the slides. So I will not try to cover it all. I will not rush it off. Okay. So one of the distinctively Asian IP development is that we have sweeping criminalizations of copyright infringement. I don't know if this is the case in Latin America countries, but Korea, in Japan, in China, in Taiwan, in Singapore, in Malaysia, it is a serious offense if you try to download anything illegal. You can be subject to 3-year imprisonment. It's worse than manslaughter. Okay, but you kill someone by a traffic accident, you will be subject only to 2-year imprisonment. But if you illegally download a song, not for commercial gains, but that can be up to subject to 3-year imprisonment. So this is very harsh. It alienates the copyright regime from the rest of the people. People just push back and don't like a copyright. Right, and yes, I can give examples about the harsh criminal punishment, 10 years, for example, maximum in Japan, and yeah, in Malaysia, even the possessions of one infringing copy can be subject to criminal punishment. And even up until this very day, in Korea, Taiwan, Singapore, Thailand, Malaysia, and Hong Kong, we still criminally punish people who manufacture optical discs without prior government approval, registrations. Nowadays, no one is using optical discs anymore, but still we have this draconian law with us, right? And another interesting feature is that we see the explosions in the number of applied and registered trademarks in Asia. So Asian people are very business oriented. We are very trademark savvy. So China, for example, annual application for trademark exceeds 7.8 million applications in 2019 alone. More than the whole world adding up together. Okay, so it's a phenomenon that you don't see elsewhere. But if you look at Singapore and Macau, for example, although the absolute numbers of trademark application and registration is small, but proportionally, actually, they have even a higher ratio rate than China. Okay, and you see a similar figure in India, for example. The number jumped up 5 times within a period of 5 or 6 years. The same thing happened in Japan, in Malaysia, right? Okay, and then we have used compulsory license with great self-restraints. I think the Latin America country, you have more number of compulsory patent license than us in Asia. So my count is that we have altogether, although we have 60% of global population, we issues only altogether 14 compulsory licenses. Okay? Only 2 are technology related, and the rest are all life-saving medicines. So that means that although we all recognize compulsory license, but in practice, China never issued not even 1 compulsory patent license. And India has issued only 1 compulsory license. And Thailand has issued the most number of compulsory licenses to deal with the issues of AIDS. Okay, but that's only 7. So my count is only 14. So the phobia that while Asian people don't respect IP rights, they are very ready to impose compulsory license. It's not true. It's not. It's basis. No, we are very restrained in our use of compulsory license. Okay, I will stop here and open the floor so that we can have some Q&A. Sorry about nagging so much. So any questions?
I can make it.
Sure.
I'm Florencia, professor, by the way. We emailed. I introduced Lucas to you.
Okay.
How are you?
Thank you for coming. Thank you for
I'm happy
introducing
to
me.
be here. So I think that my main question would be, how would you propose Asian countries and Latin American countries interact on the basis of IP? Because we have so many differences, not only development-wise, but also culturally. So how do you think there's any way to actually, from, of course, a government level, a private level, to help to aid commercial interaction and growth using IP as a catalyst?
So it's a good question, okay? And Lucas, we talked about this during our ride to the main campus, but we decided to perhaps we will have a joint conference next November 2023. We'll invite some Asian scholars to come to Buenos Aires to talk about this issue, and we will also try to invite some colleagues from the other Latin American countries to talk about this issue. And Lucas, at least according to what he has just enlightened me about your situation, is that perhaps you have more trademark related issues than patent, right? You have then more issues with the protections of traditional knowledge, and you also have issue with biotechnology and pharmaceutical technology. I think this is where actually we can try to see some synergy or some cooperation. At least we can understand each other's strength and weakness. Then perhaps we can come up with some kind of suggestions. I don't know. And as I said, also we are also will be also working with the German Max Planck Institute for Innovation and Competitions. They have a Smart America project ongoing. They are very keen also providing suggestions to Latin American countries. I can only say that I hope my first visit, I'm the first Asian to talk about IP in Buenos Aires. My first visit will mark the beginning of a new era of mutual understanding and cooperations.
That would be amazing. We've actually had many scholars from other parts of the world come to Argentina and talk about how Asia is some sort of success story that we have to imitate. And I think that there's something on a cultural level that we differ. So it would be interesting to know how to overcome those, I'm not even overcome, but to understand and internalize our special characteristics and features, just to see if we are able to develop any further using IP, right?
So yes, this is the direction to go, but I'm sorry I cannot give you an actual action plan. Okay.
Thank you.
Sure.
So I have a question. I think in the same way to Florencia, but you were talking about the Asian citizens have in feeling or really think the IP protect is to help to development and innovation. What is the best way to get it? Because in Latin America, we don't have this feeling and this thing.
Right. Good question. Actually, I think my personal understanding is that you have to reach such a level of economic development. Only then you will really be able to benefit from IPs. Before you reach that level of economic development, well, IP is actually a pure cost, nothing but cost. You have to pay, you have to ask for permission. It's a delaying tactic by the Western countries, so to speak. But then what is the economic development level? I say perhaps the per head GDP must reach $4,000 US. This is my estimate. I think.
Sorry, can you repeat how many dollars?
$4,000 US. Right, but again, dollars is rising like crazy. So
Which dollar can we ask?
Yeah, we have 1,000 million types of dollars. I don't know.
Right. The US dollar in Asia, they are quite stable.
Argentina is like a black hole of dollar convertibility.
Right. So, but putting that aside, this fluctuations of dollar aside, but I have some serious discussion with economists, development economists, and some of them agree with me. Perhaps $4,000 per head GDP is a good indicator where you can really start to benefit from IP.
Mm-hmm. But in our country, there is not all the same. In agriculture, we are very well developed.
Yes.
So perhaps we need in some sectors better standards to protect IP because we have our own innovation.
Yes.
Need to protect our own inventors. So how can we manage these different levels? Perhaps in Brazil, they have a fast track program for green technologies. Do you think that this kind of tools can be useful for our countries? Of course. To promote some sectors?
Right. Of course. You have then, we all have limited resources. Therefore, we have to choose our target very, very wisely. And as you rightly pointed out, you have your strength. Mm-hmm. Then you should really focus your IP development on your strength rather than just spread out and without any focus. Right? So agriculture is your strength. Then related biotechnological innovations, and you have the best beef. Now I can.
But the problem is that with APICs, with TRIPS, you can segregate some different technology from others.
Right.
You need a homogeneous system of patents to not discriminate one sector to other. So if you take some advantage to biotech patents, you need to give the same advantage to
yes. Right.
It's not possible to discriminate in technologies.
But there are different understanding of this TRIPS agreement. So if you read the patent declaration by the German Max Planck Institute for Innovation and Competition, they are telling a different story. They say, well, still under TRIPS, still national countries still have its leeway to design its own patent regime that best suit its national development need, especially for countries such as Argentina, which is not a very rich country. Then it's entirely justified to tailor-make IP system that best suit your needs. So India, for example, they introduced Section 3D in their patent law. They, in addition to asking novelty, non-obviousness, industrial applicability, they ask specifically for drug therapeutical efficacy. Okay, this is something not written in TRIPS. But no country dared to challenge India's practice. Okay, this is entirely justifiable. Why do we give patents for evergreen the patented drug that are actually having no actual therapeutical efficacy.
So efficacy is a new requirement in the Indian law.
Yes.
It's not against TRIPS.
No. No country has brought an issue before the WTO. No, and on the contrary, Mexico, if I remember correctly, Brazil,
the green patents fast track.
yes, they have then introduced similar provisions. So it will be unethical actually for countries to challenge Argentinian practice if you try to go your own way. Come on, we are trying to save our economy, right? So why shouldn't we be allowed to do this? When we reach that economic development level, we can be as generous or as comprehensive as the US, but we're not that yet. I think that is entirely legitimate and justifiable. Right. Any other questions?
Yeah, I think in EA, right? So India have the Copyright Act from 1956 and the Article 2D have a regulation and artificial intelligence in copyright law. So what happened in Asia with EA and copyrights, and what is the best way to regulate these relations?
Sorry, I didn't understand your question.
He's talking about artificial intelligence.
Oh, artificial intelligence, yes. We don't, until now, we don't have any specific IP regime regulating AI-related inventions. Okay? Some are devising its patent examination manual, okay, to take a more patent approach to this. But we don't have any patent regime that really deal with the issues of AI. But I think the core of these issues is really about understanding the very essence of IP. Why do we have IP in the first place? So my understanding is that really we want to incentivize new creations of human beings, not to incentivize machines or to reward machines. It's really about incentivizing human beings. So there can be all kinds of so-called new works, new inventions by machines, by AI. But this is not something we really wanted to incentivize. So we have to then track who is actually behind all these phenomena or this works. So my take on AI is really about how do you then perceive IP? Perhaps then at the end of the day, we have to change our basic understanding of IP. So my basic understanding, current understanding is that IP is about incentivizing human creation, human investment. But perhaps I might be wrong at the end of the day. But if that has come, that when we have to give machine an autonomous legal title, perhaps this is the time for us to move to Mars, right? Because it will be too dangerous for us to stay on Earth, right? Because then they can decide what is the best for them and what is the best for a human being. It can be very terrifying.
Thank you.
Sure.
One of the public. China is considered to be one of the top sources of counterfeit products.
Yes.
What is the national IP strategic stance on this issue?
Yes, the government, the official stance on this is that, well, they have to intensify the protection, they have to strengthen the protections, all this. And I think they mean it, at least the central government, they mean this from the bottom of their heart. And they still suffer from a lot of counterfeits. That's true. But more and more, as I said, if you reach the level of certain economic development, say per head GDP is over 4,000. Actually, China has exceeded that level already. So then more and more you see domestic enforcements of IP. Not that it will always come from outside of China. So you have many big companies in China already. Tencent, Alibaba, they have huge numbers of IP rights to enforce. And I think it's only in their own interest to take counterfeit seriously. I think they are very serious about this. Okay? But undeniably, they still, you see, still see a lot of counterfeits. But I think things are improving. Okay?
I have a related question to the one Lucas just asked. That has to do with enforceability in general.
Right.
I come from the entertainment world, so my connection with IP is through the entertainment industry. And you just mentioned that basically everyone is afraid of copyright law in Asia. So how would you say that very harsh IP laws and even criminal law, as far as you just said, imposes or contributes to the development of copyright-related industries, for example? Does that have a translation, or it's just plain fear from the population to download something from the internet?
Right. It's a good question. Okay. I don't know if I can see. I can speak on behalf of Asian economies, but I see the solution for copyright infringement is really in technology. Okay. One of the major reasons why we violate copyright is that really it's difficult for us to pay, right?
Of course.
So, but then with the ubiquitous take of smartphone example, actually every usage is recorded and that can be traced back to specific individuals with real names. Right, so I think that provides a technical foundation for solving the issues that we couldn't solve previously. So
under Western point of view, that would be some sort of invasion of privacy, for example. So we have
yes,
right?
Yes, good point.
So
good point.
As you said before, there's collectivism as a cultural practice in Asia, and we don't have that here in Latin America, and in many countries from the Western Hemisphere. In fact, it's the total opposite. As long as you're within the four walls of your place, you can do whatever you want. So that's the reason why I said, okay, so is this actually enforceable? Does this work on a daily basis, or it's just fear? I mean,
that worked in Asian context. Okay? And I think that worked. People are not so concerned about privacy because we want to enjoy the technology to the fullest possible extent. So then there are prices associated with that kind of enjoyment, and we are willing to pay that price because we always think we can outsmart the technology. So we just use it to the extreme. So that's why we've been driving the global economy growing. Okay, so I think technologically, there's are ways to anonymize the users, but you can still keep exact records of usage. And you can, based on that exact records, to collect royalty and distribute royalty. I think it's a good start that Google started to pay the news medias. I've been talking about these issues for 10 years at least, and we can only act collectively. And then Google will listen to us. Otherwise, they say, no, you are infringing my right as a business. But this is really unfair. They are using all the content, benefiting from all the contents without paying for it. Although we have all the exact numbers of usage and downloads. So it's a good start that countries from the world act collectively to ask Google or Facebook to pay, and they can make exact distributions. They can really fulfill the copyright promise that we want to reward actual creators. Today, copyright has failed. We don't compensate the real creators. The commercial exploiters, they got the lion's share of everything, and the poor tango dancers still got nothing. But with the help of this kind of technology, we are actually in a much better position to fulfill that promise, that the copyright promise of rewarding actual creators. So then you have to choose. You want to 100% privacy, but then there are people suffering. So you take your choice.
Yeah.
Right. Good questions.
Related to Florencia's question, you mentioned in one of the several books that you wrote, we are astonished about how many you wrote. You mentioned that pre-established damages for copyright infringement and trademark counterfeiting. This institution in Asia, how it works, which countries, and how you manage these pre-established damages?
Like statutory damages?
Yes,
Oh,
yes. It's also known as statutory damages. These are widely used in Korea, Japan, China, and Taiwan, because we are so-called civil law jurisdictions. Okay, we don't have the deposition, or how do you say, the discovery process that is commonly used in the US, for example. So then we don't have very effective civil procedures to prove the actual damages. So therefore, as a result, we just come up with inventive statutory damages. And China, again, because they were dead serious about protecting IP rights, so they just keep pushing the envelope. Now they can have statutory and even punitive damages for IP infringement across the board, for patent, for copyright, for trademark. This is just like crazy. So no country, no civilized country actually has gone that far to protect IP. I think that will backfire sooner or later, but they are very serious about protecting IPs. But I'm not a big fan of statutory damages. It can be, especially given the fact that in Asia we criminalized copyright infringement extensively. So then if you couple statutory damages with criminal punishment, it can lead to all kinds of misconducts. It will lead to copyright troll, for example. I issue a warning letter to you. Why don't you pay me the statutory damages of 10,000 Singapore dollar, which is 8,000 US dollars. If you don't pay me within 3 days, I will sue you criminally. Every Singaporean will pay when they receive this kind of warning letter. So that is, it's a...
Here it works the other way around.
Yes.
Yeah, we actually prefer to infringe and then be subject of a trial, some sort of demand or something, instead of just negotiating and paying.
Yes.
Because it's cheaper.
Yes.
Yeah.
Oh, you see?
The effective reach that they call it. So, yeah.
Okay. Then I don't know.
Yeah, it's exactly the opposite.
There is no incentive to comply with the law.
Well, again, this is a fundamental legal issue, not just an IP issue. So people have to take law as the basic norm. Everyone take law and norm very seriously. And only people have this kind of consensus and mutual trust can we talk about rule of law. Otherwise, rules can be very mishy-mashy and can be very flexible and very unpredictable. Right. So I don't know if IP can be used as an instrument to improve legal system. I don't know. I'm not that ambitious. But clearly, if you take IP seriously, it will benefit every one of us. It just takes time. Okay, so you have to tell people a long-term story. Not that you want to ask people to make great sacrifice for the common goods. No, actually, it's helping you, but only in a middle and longer perspective. It will enrich you and at the end of the day. So why don't you do this and take IB seriously? It will help you at the end of the day. At least this is my personal belief. Okay.
¿Alguna otra pregunta? Sí.
Enjoy it a lot. Thank you. Thank you.
¿Vos cuándo defendés?
Estoy terminando, creo que de aquí a octubre.
Sí.
Yes. Ahorita tuve que reunir con
Oh, yes. Masterclass.
hace la semana pasada.